Well, hello and welcome everyone. Um, Particularly our guest here, Jeffrey Kessler. Um I would like, Jeffrey, I want to go back a little and talk a little bit about your past background because, one of the things we stress with our students is that preparation plus opportunity ultimately equals success. And we've seen throughout your career quite a few victories, both in from the standpoint of management and labor, particularly, but at the professional sports level, but also now lately with the NCAA. So I would like to go back, if you can, Jeffrey, and talk about your varied sports litigation background, starting with the NBA in the early '80s, with the
Sure.
creation of this thing called revenue sharing and a salary cap. And we look at sports as a continuation of revenue sharing, with exception of the student athlete, of course, at the college level. So please take us back a little to the formation of this concept called revenue sharing.
Sure, I'd be happy to do that. But my first sports client was the NBA Players Association, and I joined the firm of Weil Gotshal Amanges in 1977, and at that time, the firm had just settled the Oscar Robertson antitrust case, which I had nothing to do with. But that was
Let me interrupt you there.
yes,
Would you just give them some idea what that Oscar Robertson
yes,
case was?
yes. That case was the first successful use of the antitrust laws to attack player restrictions in professional sports. Uh, Curt Flood had tried it earlier for baseball, but ran into the baseball antitrust exemption. And after that, it was established that that exemption only applied to baseball. So it became possible to file an antitrust action, which the NBA Players Union did, to try to stop the merger of what was then the ABA and the NBA, and also to challenge the reserve clause in basketball at that time, because there was no player movement at all at that time. Teams just had the rights to the players. And that case was settled in 1976 with a 10-year antitrust settlement agreement. And so when I joined Weil Gotshal, it was just after that. Just excuse me for a second, I apologize. So when I joined the firm, the Basketball Players Association was a client. A few years later, the NBA came to the union and said that it wanted to impose a restriction on players' spending. A salary cap was the first proposal for a salary cap, because the league claimed that many NBA teams were in bad financial shape at that
Yeah,
time.
this was shortly after the
And
merger, and they claimed that basically there were several teams that were about to go out of business.
that's right. And at the time, the union was not interested at first in a salary cap. There was no transparency. There was no real showing of the financial books. And so a lawsuit was filed under the Oscar Robertson settlement agreement uh, by Bob Lanier, who was the president of the union at the time. And that was the first uh, basketball players action that I became involved in, because now we're in 1980 and I'm at the firm a few years. And out of that case came a settlement, and the settlement was what created the model for having a salary cap in exchange for revenue sharing in professional sports. And the concept that the union came up with at that time was, we'll agree to a salary cap, although with a lot of exceptions, but we'll agree to a salary cap. But in exchange, we need a guaranteed share of the revenues. And we need financial transparency. We need all the revenue information to be shared and jointly audited and become available. And so that led to a modification of the Oscar Robertson settlement agreement that provided for that. And then in my next sort of big involvement with the Basketball Players Union was in 87, 88, when the Oscar Robertson agreement expired. We brought the Junior Bridgman litigation, which was another antitrust class action, and that one led to true free agency. The salary cap remained, and there were changes made, but it also led to the first time of unrestricted free agency in basketball. And in fact, it was the first unrestricted free agency in any of the sports. It was around the time that baseball was starting to move into unrestricted free agency as a result of arbitration decisions. But so it was close as to whether baseball or basketball had the first truly unrestricted free agents.
Yes. And that was the Bridgman case, again, focused on revenue sharing at a time when the league felt that parity was a priority, and that the idea of sharing revenue as a partnership with the players was sort of the beginning of what we see today in practically all of the sports league, with the exception of baseball.
Yes, what eventually happened is, and I was involved in that. I represented the NFL Players Association in the early 90s. We went through what was called the Freeman-McNeil litigation, which struck down the player restrictions in the NFL, and that led to an antitrust class action called the Reggie White case, which settled with a salary cap, revenue sharing system, free agency in the NFL. And then years later, the NHL eventually adopted a revenue sharing, free agency, salary cap type system. As did, there's something similar to that in most of the sports except for baseball. Baseball has always been the one which has resisted both any kind of formal revenue sharing and a salary cap in their history.
Yeah. Do you think that the smaller markets and the issue that they have in baseball, the small market versus the larger markets, that you think that pressure may be brought to bear, that even Major League Baseball will see a revenue sharing and salary cap system?
So I don't know. I don't think so, because the players union there has had a long history of success of not having a salary cap, and I think they view that as a sort of like a prime directive. And if you're fighting off a salary cap, you're not going to get revenue sharing in exchange. So I expect that to continue to be the position of the players in baseball. So I think they're just going to go their own path.
Yeah, but don't you often see that the perception of a salary cap is somewhat circumvented if you have enough exceptions to the salary cap?
Yes, I mean, basketball, has long had many, many exceptions. The first, the most prominent one was named after Larry Bird, which is that an NBA team can always re-sign its own players, even if it goes over the salary cap. To do so now in later years, Other mechanisms came into play. There's now a luxury tax in basketball, so you can exceed the salary cap, but if you exceed it by too much, there's then a tax penalty. These agreements can become quite complex, but it's certainly possible, I think, to have different systems that work, for the athletes fairly in different ways in different sports.
Yes. If we move over to the NFL and the cases that you led there, we went through the McNeil, which led to free agency. But what about the later cases?
So after the Reggie White settlement was done, there was actually 17 years of labor peace in the NFL where the agreements just kept getting extended. The Reggie White agreement kept getting extended. That lasted all the way until 2011. And in 2011, the owners decided that they were done with extending the Reggie White settlement agreement. They wanted major changes, and there was a big fight and a new antitrust litigation. It was called the Brady antitrust litigation, because what had happened is that the owners, and this happened actually first in basketball, the NFL owners sort of picked this up from basketball, was to use lockouts as a tool to try to get changes in the collective bargaining agreements that would be favorable to the owners. And the lockouts were, they basically shut down their industry. And they say, okay, no one's working until we get a deal that we like. This was a change before the NBA imposed a lockout. The first one was in 1995. And until that happened, you did see lockouts, really, in sports. But it became a tool of management to use. And so we filed an antitrust case against it, claiming it was a group boycott in violation of the antitrust laws. And we sought a preliminary injunction against it, which was granted at the district court level. But in the Eighth Circuit, by 2-1, it was held to be barred by what's called the Norris-LaGuardia Act, which is an old statute that was removing the court's power to enjoin strikes, and they argued lockouts in certain cases. So we were then fighting to get damages in that case because we couldn't get the preliminary injunction, and that pressure eventually led to another settlement in the summer of 2011, which led to a variety of changes, but basically maintained the same free agency salary cap system that's always existed in football since 1993. But there were definitely some changes on both sides of the table as to how that system worked.
Okay, well, let me take this moment in time to let everyone know in the audience that if they have some questions they want to raise, to please go to the chat, and at the end of our conversation, we will engage Jeffrey in some of your questions as well. But Jeffrey, let me also go back and say that there was a time when one of the ideas that came up that certainly came out of Wagachol, if not you, and Jim Quinn, that we thought about decertifying the union as a way to use leverage in these negotiations. Would you chat a little bit about that?
Yes. So this was what led to the Junior Bridgman case that I mentioned earlier, well, it was during the Junior Bridgman case. There had always been a dispute between the owner side and the player side as to whether you could have antitrust litigation while you're also engaged in collective bargaining and being a union. And the law was very uncertain. It came up in the original Oscar Robertson case. That's where it first came up. And here was being raised again in the Junior Bridgman case, and the idea, what led to the Bridgman settlement, was that the Players Association, and it was Jim Quinn and Larry Fleischer at the time who developed this idea. Larry Fleischer was the head of the union at that time, and the idea was they told David Stern that we've collected cards to end the union. So you'll no longer have this argument that you have a protection from antitrust because we're a union, and then we're just going to go forward and get all the damages and get all your restrictions struck down. And that threat actually led to the creation of free agency in the Junior Bridgman litigation. They settled that. And then we took up that idea, Jim Quinn and I, for the players that led to the Freeman McNeil case, because what had happened is in football, they got an adverse decision in 1989. This was after Bridgman, that ruled that because they were a union, they couldn't pursue their antitrust cases in a case called Powell versus the NFL. Marvin Powell was the head of the NFLPA at that time. And that's when Jim and I got hired at Weill Gottschall to take over, and Gene Upshaw, who was the executive director at the time, said, what should we do? And we said, well, look, this worked in basketball. We think we should get rid of the union if it's being used against you, and let's just pursue antitrust. And there actually was no union in football from 1989 all the way until we settled in 1993. There was no union, and that's how we got to the Freeman McNeil verdict. And it was only when we settled the Reggie White case that part of that case was the owners said for the settlement to take effect, you had to agree to reform the union within 60 days, which is what we did, because at that point we achieved what we wanted to achieve in free agency, so we were willing to do that. And since then, there's always been this tension between labor law rights and antitrust rights, and the Supreme Court eventually decided in a case called Brown versus Pro Football that the way that you could clearly get rid of this antitrust protection was to end the union representation. And we did that again for the NFLPA year in 2011. When we were bringing that Brady case, we disclaimed bargaining again in order to do that. Interestingly, the NBA players have never actually decertified.
Yes.
They threatened to do it.
Threatened.
And in 1995-96, there was a kind of interesting period in history. The players actually split with each other. At that time, the Players Association was headed by a guy named Simon Gordine, who you knew very well, Charlie.
Yes.
And they made a deal that a very large number of players, particularly the bigger star players, objected to. And I actually was removed as counsel for the union at that time by Gordine, and Jim Quinn and I were both removed. And we got hired by the players to actually try to get an election to decertify the union against its will, so that we can bring an antitrust case to enjoy the deal that they were going to put into effect.
I think that was Jordan and his group at that time. Yeah,
it was Michael Jordan, Patrick Ewing, a whole bunch of other players. And ultimately, we lost that election by about 50 votes. And it was a very odd situation because the union was working with the league to fight the other players, and it's terrible when players are divided against each other. And the ultimate result of that was, while the league defeated the decertification, ultimately the players then replaced Gordine as the executive director at the end of that year. And in 1996, there was actually no executive director. There was only an interim executive director until a new one was chosen that summer. And eventually the players came back together around that. But it shows you the type of, strange paths that these things could follow.
Yeah, well, I recall very much the early on doing Bridgman for the decertification effort, because at that time I was the one collecting all the signatures. So by the time we were able to make that statement, I believe that David Stern believed that the challenge to the law was so unsettled at the time that he believed that we may have had an edge, and it was only at that time that we ended up with the Bridgman settlement agreement.
And it was before he came up with the idea of a lockout.
Exactly.
At that time we were just able to challenge the salary cap and the restrictions, and he was very worried about that. You'll also remember very well, Charlie, because this was under your stewardship as executive director, the importance of financial transparency. We ended up having a RICO case.
Look, I remember that very well. Are you kidding me?
A racketeering case under your leadership at the union, because it was accidentally uncovered that the Chicago Bulls had a lawsuit against the NBA in which their financials came out and revealed different numbers than what were being reported for calculation of the salary cap.
Yeah.
And we ended up
matter of fact, we had a guy named Charles Bennett sitting in the courtroom when they had to reveal those financials and the numbers.
Right, and that led to another settlement, you'll recall, in which they agreed to provide much more access to the union to audit their books, and that then became a tenet of all these deals. So in the NFL CBA, the union has the right to audit individual teams, and in the NHL CBA, the union has the right to audit individual teams. In all these revenue sharing systems, it became important to be able to have that transparency, because basically the players don't trust the owners to otherwise report the correct numbers.
Yeah, in addition, what we discovered was that no matter the buckets that they were supposed to deposit the money based on the definition of revenue share, they were not only cheating us, but they were also cheating the league, because a certain percentage of that had to go back into basically fund the league office. So that's
absolutely true. We had that experience in the NFL as well. We once had a proceeding with our right to audit and challenge the revenue against the Raiders, who, when they had moved back from Los Angeles to Oakland, remember, they went from Oakland to LA, and then they went from LA back to Oakland. Al Davis actually was hiding a whole bunch of revenues, but he was hiding it not just from the union, so it wasn't going into the salary cap, but he was hiding it from the league, because it would have had to go into revenue sharing for the league. So the league was actually very happy that we brought this case that uncovered this money, because even though it increased the salary cap, it also increased the Raiders' duty to share with them. So that could happen.
Yes. Jeffrey, given all this, and I think what I'm trying to do here is to link your experiences at the professional level with what I believe ultimately may appear at the college level, meaning that if we take a look at the Alston case and we take a look at Justice Kavanaugh and his point of making a course correction, I think his wording was course correction. And to me, that opened up many, many more questions as to what is down the line for the challenge regarding the potential revenue share, or these athletes now becoming more involved in sharing this revenue.
So the interesting issue you're raising is whether or not there could ever emerge, the equivalent of a union, for the college athletes. Right now, they clearly have the antitrust laws available to them, but they don't clearly have unionization available to them. And the reason for that is there was an effort made to unionize at Northwestern.
Yes.
Several years ago, the steel workers were working together with a group called the College Players Association, and they tried, and they actually got to an election, and the athletes did vote on the football team to unionize, and that went up to the NLRB board. And the problem there was, and it still is something of a legal obstacle, is that in the Big Ten, which was the conference at the time, Northwestern was the only private university. All the others, Ohio State, Michigan State, Indiana, all of those schools are state universities. And in many of those states, there are state laws that state workers can't unionize. So even if you found that they were workers, you couldn't overcome these state statutes. And what the NLRB did at the time, and I thought it was a very weak decision, they said, we're not going to decide whether or not you can have a union here at Northwestern, because as a matter of prudence, just unionizing one school out of the Big Ten wouldn't be effective, because you need to have these rules negotiated on a conference-wide basis. You couldn't have different, you couldn't have Northwestern paying salaries and not having the other schools paying salaries or doing different benefits and things. So we're going to say that as a matter of prudence, we're not going to recognize this union now, and they stopped it.
Right.
Now, recently, after we won in the Supreme Court in Alston, the general counsel of the NLRB, and now we have a Democratic administration, so a slightly different view than at that time. So there's a majority of Democratic NLRB commissioners who are going to be more pro-union. The general counsel said, these are employees, and they have the right to organize, and we'll exercise our rights over that. But that memo says I'm ruling on this at least for private schools. So it still has that barrier there for public schools. Now, Congress has proposed legislation out there which would change that. There actually is proposed legislation that a number of unions have endorsed and others have endorsed that would overturn that rule and not only declare that the athletes could unionize, but override the state laws. And you could do the federal legislation.
But let's stay there a minute, Jeffrey. Let's stay there a minute, Jeffrey, because clearly that general counsel statement would allow even private schools to do that. But is it time for the professional sports unions, particularly in football and basketball, is it time for them to get off the sideline, so to speak, and engage the college athletes on a couple levels? One, that you could have perhaps a associate membership free of charge, or I could send my player reps to campus to help organize, because the main problem that it appears that these college kids have is this concept of being organized, because they're fearful of losing their scholarships, they're fearful of the coach, their parents, et cetera, which is what happened in Northwestern. So,
again, I'm not going to, to speak for the unions, but, I think this is, an issue I think actually the unions are interested in this issue. I know, for example, that the NFLPA was supportive of the steelworkers and Ramogi Yuma when they were trying to organize the players in Northwestern. So I think I think there is interest and support in the unions. When we went to Alston, both the basketball players and the football players union joined in a brief in support of an amicus brief, which I think was actually very helpful, along with some other unions. Also, the WNBA Players Association was involved in that as well. Supporting the assertion of antitrust rights. So I think there's interest in the professional unions because, after all, the vast majority of their members went through the college system. So it's not like there's a disconnect or a discontinuity between that. But to me, for unionization to really be effective, legislation like that proposed in the Senate really would have to be adopted, so that because to really effectively do this, you need the ability to unionize a whole conference, especially the power conferences, to be able to do that.
So Murphy's bill is the closest to doing that. Whether or not they get bipartisan support is another issue.
Well, they don't have it yet. They've been working on it.
Yeah.
They've been trying to get it. I guess we'll have to see, what happens in the future. But look, the college issue has been evolving for many, many years. And, we could never have gotten a unanimous Supreme Court to rule the way it did in Alston, even maybe 5 years ago.
Yes.
Let alone 10 years ago or 15 years ago. We've had now a number of states pass laws to allow names, images, and likenesses, which combined with Alston has allowed that to blossom. So, I think that this NCAA picture is in really a moment of dramatic change. And, we'll see how this evolves over the next few years. It wouldn't surprise me if you don't get bipartisan support eventually, or you don't get a lot of states even on their own saying their state workers can unionize. Remember, you could do it at the state level too. If Michigan and Ohio and Texas and starts repealing those laws just for their colleges, right? And saying yes, you would allow. You don't have to repeal it for everything, but repeal it for those colleges. That's another way to get there. So we'll see. But I don't think it's going to be a very successful strategy in the long run unless you could do it for all the power schools, because this is most important is in those 5 power conferences that generate such dramatic. I mean, we're talking about revenue. The collective revenue of Division I basketball and FBS football is greater than the revenues of the NBA.
Yes.
It's greater than the revenues of the NHL, and it's greater than the revenues of Major League Baseball. It's second only to the National Football League.
Yes.
In total amount of revenues, and they're concentrated in about 65, 70 schools. It's not everyone. That's one of the myths too. No one has ever said that if you're dealing with a school in the Patriot League, that doesn't even give sports scholarships, that they are the same business animal, as Texas or Ohio State or Alabama or any of those other schools. They really are different situations with respect to this challenge of exploiting the athletes and the economics.
Well, that Forbes now puts out a list of the most valuable college and universities sport programs.
Yeah.
University of Texas and Texas A&M at the very top. But Jeffrey, I take this way back to the 80s and early 90s when rookies would come into the league and I would congratulate them. I would ask them to a person, what about the guys you left behind? All the ones who helped you become a #1 draft pick. And at a time when there are only 60 first and second round basketball players, or 6 rounds or so for the football players, and we look at this mass of college athletes out there, recognizing that 0.5% of the football players will even get a chance to be drafted.
Yep.
At some point here, do you see that the NCAA as an institution, they're much like the owners of the NBA, the owners of the NFL, Major League Baseball, etc., in terms of their inability to grasp, we want to share this revenue with these athletes?
Yeah, so look, I do think it's, as I said, it's changing. It's already changing. The fact that they removed most of the restrictions on names, images, and likeness payments.
But wasn't that a strategy? Was that a strategy for them? They gave up something that was not of much value to them, which is being borne out here.
Well, it's of great value to the athletes.
Yes.
It may not be, in other words, it doesn't come directly out of their pocket.
That's
you're right.
That's my point.
But you have now thousands of deals being made this year in not only in college sports and not just basketball, football. You have volleyball players and gymnasts and and rowers and others getting all sorts of deals because they're on social media and they have other ways of developing their income. You even now had the first high school basketball player who has signed significant deals now. So at least this is a way of getting some financial support and assistance to these athletes. But no, it still doesn't solve the basic problem that they don't share their revenues. We have an antitrust case right now called the House litigation. And one of the arguments we make in that case is that they take the names, images, and likenesses of the players and they give them to broadcasters. And they get all this broadcasting revenue. And then they have rules that prohibit the schools from sharing any of that revenue with the athletes by compensating them. And so that's actually something we're seeking as a matter of antitrust law in the House case.
Yeah, because it's pretty clear that they're shifting the name, image, and likeness for the student athlete. That's to keep their eye off the real prize, which is sharing the revenue that the universities utilize their name, image, and likeness to get these television contracts.
And that's why in House we're trying to link that together and say we should have damages because the schools should be competing with each other to share those broadcast revenues in exchange for utilizing those names, images, and likenesses of the athletes. And it's interesting because in their contracts with the networks, when they do a contract, they actually warrant, we're giving you all the rights that you need.
Yes.
Well, where are they getting those rights from, right? And they're not paying for them, right? And so that's part of what we're pursuing in the House litigation, and we'll see how that evolves. But look, one way or another, I think this system in college is not able to survive in its current form. I think the NCAA itself knows that. You see, they're now having a constitutional convention where they're going to restructure themselves. I think part of that restructuring is going to be to break out the power conferences and give them more control over what they do individually, which is, again, I think going to lead more to the opportunity for the type of legal and other solutions we're talking about to eventually recognize that some of these schools are in effect engaged in major commercial enterprises where they basically conspire to fix their price of labor, right? And
Yes.
that and I think the restructuring of the NCAA is going to make that even more evident as they sort of push those schools almost into their own governance category, which is going to isolate that issue more and more.
For our audience, would you briefly distinguish between the O'Bannon case and what happened in O'Bannon versus Alston?
Right. So O'Bannon was a challenge to the names, images, and likeness restrictions, and actually in that case, the restrictions were held to be an antitrust violation as being overbroad, but the remedy was quite limited. The only remedy that was found and sustained was to allow there to compensate the athletes through full cost of attendance scholarships, because, and people don't realize this, prior to O'Bannon, which was not that many years ago, 2015, 14, 15, when this happened, schools were not even allowed to give full cost of attendance. All they could do was waive tuition and give you free rooms and give you 3 meals a day in the dining hall. They couldn't provide you with any other expenses of the education. So, like, for example, if you get a Pell Grant, you get all these other expenses covered. Schools weren't allowed to do any of that. Now they are, since 14 and 15. The Alston case didn't challenge the names, image, and likeness restrictions. The Alston case went after the compensation restrictions. So it was just a different lawsuit. And we also won, but we also got a limited remedy. We got struck down all the restrictions on education benefits. So, for example, now the colleges can give you unlimited study abroad and computers and tutoring and internships and even a graduate school scholarship. If they're so inclined, that they can give you an academic achievement award of several $1,000s, equal in value to what they give you for athletic achievement if you get to a bowl game or something like that. That's all allowed, but we still didn't strike down the rest of the compensation restrictions. And so that's still to come. This is a process. It's, one thing, that's clear in the legal world. Justice Ginsburg was a justice who spoke about this. It's really hard to effectuate complete change all at once. It's usually going to be a process of steps of legal decisions. So I felt like O'Bannon was an important first step, or was a small step to get to Alston. Alston's a much bigger step. Hopefully House will be a step that will take it even further, and then eventually maybe we'll get legislation and other things that will let us go even further. But I do think that that's the flow of history, is that this system is coming apart.
Okay, I agree. Let's go back to Justice Kavanaugh.
Yes.
His opinion, concurring opinion, when he talked about the course correction, does that suggest that there are damages for many of those students who have been denied such access? And I think of recently, there was a report that came out that said since 2005, predominantly Black athletes have suffered from the tune of about $17 billion in losses.
Yeah, look, there's no doubt that the damages, if you went back that far, would be staggering. And there's also no doubt that Black athletes have suffered disproportionately. What a shock! Just like people of color suffer disproportionately in so many things. But as a legal matter, even if you could go back in antitrust, we've got a 4-year statute of limitations.
I see.
So there's really not a current legal mechanism. Like in our house litigation, we're seeking back damages for 4 years from when that case was filed. So we will pick up on the athletes, in that period of time, but we can't really go back and get athletes before then, again, unless Congress were to step in and to do something else to create a longer lasting remedy. Or if there ever was a union, unions could always negotiate giving benefits to former players, just like the professional unions went back, and have increased the pensions and the health care and the retirement benefits for past basketball players and past football players. And, you could do that, I guess, in college too, if you ever got to that type of situation.
But back to Justice Kavanaugh, he seems to be inviting some of this litigation going forward.
I think Justice Kavanaugh's view is that if he was the trial judge, he would have granted us complete relief. He would have struck down the whole set of restrictions. And he's basically saying is that he believes the majority opinion of the Ninth Circuit, while it did not reach that issue, that the principles of that issue, of that decision, the lead you in that direction. Because, for 37 years, NCAA had cited this old Supreme Court case, Board of Regents,
right,
argue that there was dicta in that case, which there was, that sort of extolled the virtues of amateurism. And they used that to argue that if they're doing something in the name of amateurism, they're entitled to some special deference and treatment under the antitrust laws. And there are a number of courts who agreed with that, and that they won a number of cases on that principle. And the majority opinion, the 9-0 opinion, clearly rejects that and says that if one, that's not what Board of Regents ever meant, but if it ever meant it, it was dicta, and it's 37 years ago, and the world is different today, and it no longer can have that meaning. So that, as Justice Kavanaugh wrote, the NCAA is not above the law. They're subject to the same rules as everyone else. And what he's basically indicating is the implications of that is that in future cases, the rest of their restrictions should come down, right? Now yeah. He's only one justice. He didn't get another 8 to join that, but he's basically saying that that's his view of the implications of the decision. And it's also true that we didn't ask for that at the Supreme Court this time, because we were trying to preserve the victory that we won, which is very important for the classes. And so, and the justices asked me this during the argument. They said, you haven't appealed to ask, for broader relief than you had achieved. And the answer was, that's correct. We made a strategic decision to go to preserve what we won, right? Because that's what they were trying to overturn, and then look to future cases, to revisit the broader relief. And so it really wasn't before them. But despite that fact, Justice Kavanaugh wanted to write an opinion saying, I think this is where this is going to go. So he's obviously very pleased with that.
Yes, but he also seemed to suggest that the rule of reason was not properly applied over these last 35 years or so for some of these cases.
There's a big issue there, and I'll tell you how that may come up. And we're litigating this in-house right now. There is an argument that under the rule of reason, you're supposed to balance what's called pro-competitive effects versus anti-competitive effects. Everyone knows this is anti-competitive. So the issue is, do they have pro-competitive effects that are offsetting, that justify it?
Right.
There is this legal issue that the pro-competitive effects, they argue, are not in the labor market. They're in the market, they say, for college sports to compete like with professional sports, it's the output market there. And there is a big legal issue of whether that's even possible. In other words, they may have to prove pro-competitive effects in the labor market. And if that becomes the rule, then their whole system can't be justified in any way, shape, or form. That's going to be one of the issues we're litigating in-house. So again, that could have very significant implications if we get the district court and then the Ninth Circuit to accept that. And then, of course, if we do, they'll try to go to the Supreme Court again. But that could be the way in which finally it becomes clear that the NCAA shouldn't be in the business of restricting any of this compensation.
Correct. Going forward, and again, we look at the NFL, the NBA, Major League Baseball to some degree, hockey, etc. All use the same business model. And is that business model applicable at the college level?
It's theoretically it could be. There's no reason why, again, if there were unions who were negotiating and if it was allowed and it was allowed for all the schools, you couldn't have a revenue sharing model in those sports. So there are always two ways to get what I view as a fair result for the players. One result is complete application of the antitrust laws and full competition that's unrestricted. And the other way is through a collective bargaining agreement that develops a sharing system or some other system that the parties agree upon that lead to a fair result for both sides. So yeah, they're both options, could be available if Congress would help get rid of the barrier to unionization.
But part of what the NCAA would like in return for whatever modification you see here is a antitrust exemption. Now, I don't see how they could possibly maintain the current business model and also expect an antitrust exemption.
I don't see it either. They asked for it. They have some members of Congress who have proposed something like that, but I don't see them having a majority of either the Senate or the House who would support such an antitrust exemption. In fact, it's all going the other way. All you see every day is new bipartisan proposals to further rein in the power of the NCAA. You just saw a new bill introduced, I think, this week that would limit the NCAA's ability to unfairly punish schools and not providing due process there, which is not really a player issue, although it is indirectly, because one of the principles they have is that when the NCAA does do a punishment for someone who's cheating, that they should punish like the coach and not the players. What happens now is that, so you had this scandal involving coaches. You saw this, I think, just yesterday in Oklahoma State, where they imposed this penalty on the school for a coach who was getting money for diverting athletes from Adidas. And I thought the school made a very good point. Why are you punishing like the athletes today? So someone who's a student today at Oklahoma State who wasn't even at the school at the time this happened because some coach, did something for himself that violated NCAA rules. Today's Oklahoma State player can't be in the NCAA tournament. And that's one of the things this new legislation was getting at too, saying you can't do it that way, that the penalty should be, punish the administrators or punish the coaches or the athletic directors. Why are you punishing the athletes, right? If the athlete had nothing to do with it, that's different. If an athlete was violating NCAA rules, that's different. But in many of these cases, the athletes who are getting punished have nothing to do with the alleged violation.
Let's take a good look again at your case called the House. I guess you said that would be the next one on the agenda.
Yes.
What's the status now as we speak?
So that case has survived the motions to dismiss, and we are now in discovery process. So we haven't started depositions yet. We're in the process of getting documents. There's lots of document fights and evidence that's being gathered. And then there's going to be a class certification motion next year, and that's going to be a huge issue. They're going to vigorously try to fight the classes. We have classes of current players and of past players, for different types of restrictions. And so we're going to have a big fight over class certification. Once the classes get certified, and I believe they will get certified, then we'll move into merits, to further merits discovery, and then hopefully get to a trial. But the first step is class certification, which won't take place, my guess is, until the second half of next year.
Okay. Going back to Justice Kavanaugh again, because I think his concurring opinion, to me, sort of puts a sort of writing on the wall to some degree. But did he not also introduce the possibility of civil rights as being an issue as well?
So indirectly, I think both his decision and the decision of the majority, the 9, talk about the exploitation of the athletes and and how they're mistreated and how they're exploited, and that could theoretically prompt different types of claims. I'll give you a couple examples. The NLRB General Counsel, in talking about the abuse of their rights as workers, cited the Alston decision for that, even though Alston's not a labor case, it's an antitrust case. You have cases trying to apply the minimum wage laws to the athletes. There's one going on right now in Philadelphia, trying to apply it to the NCAA athletes, and that case cited Alston, arguing that, if you recognize them as workers in this type of system, then why don't the minimum wage laws apply to these athletes? So yes, I think some of the facts found there, could there be arguments about, civil rights violations or other types of violations of law? Certainly, we've seen huge attention to gender equity. There was the huge controversy over the women's version of the NCAA Final Four, and how poorly they were treated in comparison. And there was a study done of that. And you might see Title IX cases, on gender equity brought. So Title VII is on race discrimination. So you could have those cases. Frankly, I haven't studied those areas in college to see if there's a case to be brought or not. But certainly the whole concept that these are a group of monopolists who get together and exploit these athletes for their own benefit raise all sorts of legal issues, beyond the antitrust issue that was just decided in the case.
Very good. Jeffrey, if I look back at the number of cases that you have initiated, tried, is there a favorite one?
Is there what? I'm sorry?
A favorite. Is there one that makes you feel better than others?
It's hard to, it's like picking between your children. I love them all equally. I guess I could say, in terms of impact, the 3 cases that I've been involved in that had the greatest impact were Freeman McNeil in football, because that led to free agency in the NFL, Bridgman in basketball, because that led to unrestricted free agency in the NBA, and Alston, because of the impact that it's having on the college athletes. So if you're looking at what's had the greatest societal effect, those three have, I think, have accomplished the most. So in that sense, I think I take great pride in those. Maybe, it's certainly they're among, if not my favorites. Those three would be there.
Good. Well, let me take this moment again, Jeffrey, to thank you for your efforts during the time that I served as the director and executive director of the NBA players, because I've always seen that your work and the doggedness of that approach. I think Gene Upshaw, my former friend, would be the first to say that when things go foul, I look for my litigator, Jeffrey Kessler.
Well, thank you.
With that, what we're going to do now is open it up for some questions. I think I may have mentioned Len DeLuca, who's also a professor at Seton Hall, is been monitoring through the chat the types of questions or the kinds of questions that have been raised. And at this point, I would like to have him open up for Q&A. Len?
Thank you, Charlie, and thank you, Jeffrey. We have great questions, and they break into NBA, college, and women's soccer. So
Okay.
let me open with the NBA duo. Of the three major sports leagues in the U.S., Jeffrey, with the salary cap, the NBA is the only league with a soft cap. How much does this hurt or help the NBA players and teams? And while you're thinking of that, the second half of it is recently, what is your thought of Illinois' Kofi Cockburn suspension of 3 games for selling memorabilia during the NBA draft process? Thank you.
Okay. All right. So the salary cap issue is interesting. Each of the 3 salary caps are different. The NBA has the most exceptions. Players obviously like exceptions to the salary cap because it allows them to have more ways to have a freer market and greater compensation. And so that's always been a benefit of the NBA system. I don't think the NFL salary cap is actually a hard salary cap. It doesn't have the same set of exceptions as the NBA, but it actually has a whole bunch of other mechanisms that allow teams to pay more than the salary cap. So as long as you can pay more than the salary cap in some way, it sort of gets there, in another, direction. I mean, the real advantage that basketball has over football is that it's much fewer players. And so that, and frankly, the risk of injury isn't as high as it is in football. That's not to trivialize that there are injuries in basketball, because there certainly are. But certainly, football is the sport that has the greatest amount of injury, and so football has some disadvantages, both in terms of the number of people who have to share the salary cap and the threat of injury, which shortens careers. And I think that's been a lot of the reason why the outcomes, you could say that, basketball players could generally have longer careers without injury, and have much higher average salaries, certainly, because it's a much smaller group of players who are sharing in it. So that's worked out for them. Hockey has the most restrictive system, in many ways, right now of the 3 sports. They've gone through a lot of turmoil in hockey that led to that. They actually were locked out an entire year in hockey during that period of time. Now, had I been advising the hockey players at that time, I was not. I would have urged them to decertify and bring an antitrust case. They didn't do that. They tried to sit out the lockout and it's sort of like last longer than the owners. And I give them credit. They lasted a year. But what happened is after that year, they fired their executive director, had a revolt, put in a new executive director who then made a deal that led to this system. And, so that's how hockey ended up with that. I'm not going to comment on the other issue because I'm involved for the union, so that's an ongoing matter, so I don't think I should say anything there.
That's totally fair. Let's turn to
Okay.
the college couple of questions, please. Someone writes, do you think the new case regarding former players seeking NIL damages will be a win too? And coupled with, all right, let's just do that question.
It's the same case. So the House case, we cover current players and any player who was in Division One. Well, actually, it's really Division One. This case, we don't limit it to football or basketball. It's really all of Division One sports for NIL, because in NIL, the payments can be made even if it's not a big revenue sport. As I was saying, the gymnasts get it, the volleyball players get it. There are lots of factors that allow people to get that money. So it's all those players for the past 4 years from when the case was brought. And yes, I do think it's going to be successful, and I do think we're going to recover a large sum of money. We'll see if I'm right. I'm not the decider. There'll be a judge who's the decider, and a jury if we go for damages. If we don't settle, and so we'll see if I'm right. But I think that's coming.
The last college question is: my current school has a grad student union at the state school. Can an athlete potentially use the interstate commerce clause as a way to form a union, given the existence of other student unions? So
the answer is, according to the NLRB right now, an athlete can try to form a union at a private school. And, whether the public schools, universities, I said, have their own issues because of state laws that prohibit, unionization. But there's never been a real doubt once the NLRB, if they're willing to agree to it. Now, by the way, the general counsel is not the final word. Ultimately, if there are going to be unions, even at the private schools, I have no doubt the school will challenge it to the NLRB itself. And that even could go on an appeals court to challenge beyond that. So we'd have to get through it. But at least the general counsel, the NLRB, has said that there can be again.
Okay, turning to the soccer, U.S. women's national team, how well do you see them, the U.S. women's national soccer team, doing on appeal? So
we are very optimistic about the appeal of that case. For people who don't know, we represented the women's team in bringing an equal pay case under Title VII and also under the Equal Pay Act for both pay and working conditions versus the men's team. We settled successfully the working conditions and have gotten that in a class action settlement, but we lost summary judgment on pay in a decision that ruled that even though the men's team had higher rates of pay, the women's team hadn't showed they were discriminated against because over a 5-year period of time, they actually earned more money than the men's team, which is correct. And the reason they did that is because, for example, they won the World Cup and the men didn't qualify for the World Cup. So yes, the smaller bonuses they got were greater than the zero bonus that the men got for not making the World Cup at all. And somehow the court ruled that means you don't have unequal pay. We think that's wrong. And a lot of other people think that's wrong. We have advocate support from the EEOC and the United States government. We have advocate support from a host of EEOC officials from past administrations, both Democratic and Republican, who think that's wrong. We have advocate support from the men's team. The men's team put in a brief saying, yes, the women's team are being discriminated against because under our deal, we would have gotten much more money had we achieved what they achieved. So we are cautiously optimistic that that's going to get reversed in the Ninth Circuit next year, and then we'll be back at a trial. and I like our chances at a trial.
The last question, and I appreciate everybody who has offered us questions so far. First of all, let me start because this is mine. Congratulations, Mr. Kessler, on being a rare litigator who can unify the Supreme Court. Not a lot of 9-0 decisions. Is it accurate that it was Justices Kagan and Kavanaugh who were closest in their oral and written criticism of the NCAA?
Well, so we don't know about written because there was a 9-0 decision, which everyone joined in, and then there was Kavanaugh separate, which it was just for him. But I would say that during the oral arguments, Justice Kagan was extremely biting and critical in her questions of the NCAA, as was Justice Kavanaugh. But they also were not alone. There were several other justices who were, really hostile to the NCAA's positions. I'm wondering, how many justices actually agree with even Kavanaugh's concurrence.
Yes.
I think there is some number who do. The reason I think they didn't join it is because there is a philosophy not to decide issues that weren't presented. And so they, the 9 stuck to the issues presented and left open the others together. But I think had we presented some of those other issues, you would have seen more justices, Justice Kagan and perhaps a number of others join in that view. That's what we may find out down the road.
Okay, and last, as with only 3 decades or 3.5 at ESPN, CBS, and IMG in my life, should those representing players consider, hearing your comments, suing the media networks for their part in the college system? Wouldn't the networks argue that they are part of this, not part of the decision how to disperse the rights?
Yeah, so it's hard to do that under the antitrust laws because they are not direct participants with the network. The schools are a layer between them and the network. So I don't know that there really would be an antitrust case directly against the networks. You would have to know a lot more conduct that I'm aware of that would probably raise that type of issue. Now there are some other interesting issues about whether the networks in fact have all the IP rights they need from the players to conduct their broadcast. That's not an antitrust issue. That's an IP issue, and that could come up in some way, perhaps in the future. But I'm not sure that. I think the antitrust responsibility lies squarely on the NCAA and the conferences.
Thank you, Charlie. That's it from our great group.
Okay. Well, Jeffrey, thanks a million. Great to see you again. Again, I thank you for our time together back in the 80s and early 90s. And I wish you the best. And we hope to see another case coming down the pike here pretty soon.
Okay. Well, thank you very much. I appreciate the opportunity and I enjoyed the discussion. Everyone have a good night.
All right. Good night, everyone. Thank you again for your support and have a nice weekend.